Hi, I'm attorney Frank Malatesta. Um, I practice employment litigation throughout the state of Florida. Most of my work is done on the plaintiff side. I do work with a number of small businesses doing some defense work, but most of it's on the plaintiff side. And I wanted to talk today a little bit about discovery. What does that entail? What does it involve? A lot of the discovery that gets done um, in your standard kind of smaller litigation is going to be done not necessarily by your attorney, but by you. So you're going to have to collect your emails. You're going to have to collect your documents. You're going to have to collect your text messages. You're going to have to collect your letters that you might have sent to your employer or to your employee. You're going to have to collect all of this information. Now, typically at the beginning of the litigation period, you're going to receive a litigation hold notice or you're going to know you're planning to litigate a case. So you have to preserve, you're under a duty to preserve that information. And if you don't preserve that information, then there's assumptions that can be taken against you, there's sanctions that can be brought against you. So it's important that you are communicating effectively with me as your counsel, you're disclosing everything, and that you're preserving documents. The EEOC process is a great example. You might file today in 2017 in October, and we may not go to trial until 2021. That's just how the process works. It takes a little bit of time. But you're under a duty to preserve evidence. And it's very important, especially if you're the plaintiff, that you are preserving every type of evidence and you're taking actions that are going to create a written record of what you're doing. I'm not talking about a journal, although that is discoverable as well. Personal journals are absolutely discoverable. I'm talking about if you communicate with your employer, communicate in writing, send a letter. If you're a business, communicate in writing. And be meticulous about what you put in that writing, what you admit to, what you don't admit to. If there's allegations going around, you need to write a memo. You need to have that memo up. You need to have counselings. You need to take appropriate action to protect yourself in the litigation should it reach that avenue. So just be aware that discovery starts as soon as you think you have a lawsuit. If you get a litigation hold notice from a plaintiff's attorney, you need to be on top of it. You need to make sure that you are preserving as much information as possible because it can be held against you should you not do that. Things happen, obviously, and if you don't have it, and it's been 4 years and this litigation won't go away, obviously we're going to have to go to the judge, we're going to have to explain it. But you have to be preserving that information and you have to be prepared. And if you are the plaintiff in a situation, you want to be creating a record as you interact with your employer. Hostile work environments are great, but there's no economic damages there. And if an employer takes the appropriate steps and doesn't retaliate against you, you don't have a very good case per se. But the goal, if you're an employee, in my opinion, it's not to necessarily, unless just something horrible has happened to you, it's not to create or manufacture a lawsuit. We're not going to be able to do that. What you're doing is you are protecting yourself and putting in writing as you engage in protected activity. Just like if you're an employer, you're going to want to communicate in writing. You're going to want to make sure that you're keeping all of your communications with your counsel privileged and you're protecting yourself. It also means you have to make sure you're not retaliating inadvertently or creating situations that just aren't with it. If your person's had a schedule who's causing problems or has reported allegations of hostile work environment, don't go changing their schedule. Don't go retaliating against some stupid stuff. You're creating a headache for yourself. Although these things happen and sometimes people just can't reconcile. The goal really is to just be aware, whichever side you're on, that anything that communicates an issue that's not privileged is going to be seen. It's going to come out in the litigation, and you have to disclose it. You can't hide it. If I find out one of my clients is hiding documents, I'm going to drop them like a bad habit, because as an attorney, I have to act in good faith. So you as my client, I expect you to be aware. And that doesn't mean that we're hiding stuff, as in you're not creating bad records. So it's kind of a little bit of an issue. So the pre-litigation stuff, we are being intentional about how we interact, if that makes sense. So we're communicating in writing. We're not sending text messages at 11 p.m. after we fired somebody and giving them an explanation for why they fired somebody. We're not acknowledging employee requests for an explanation on why they were terminated. This is an employment at will state. We don't need to give them anything until litigation happens. But we need to preserve our records on our side before the employer. I know I keep jumping back and forth, but it's an interesting discussion, and it's an issue that comes up in every single case I end up filing in court, and even before I file in court, because preservation of evidence is something that has to be done, and the interrogatory process and the deposition process, truthfulness and collection of all potential evidence is a part of what has to happen. So one of the things defendants or plaintiffs don't really understand is a lot of the work that gets done is just looking up all this information, answering questions, sitting through deposition in preparation for trial, and 99.999% of the time, we're not going to have trial. It's going to be settled at summary judgment, or it's going to be settled at another stage of the litigation. So regardless, you guys have a great day. Just an interesting topic I was thinking of today, and I wanted to have post this video. Thank you.